Case number 1. Don R. Ickes, the plaintiff, versus the FAA, the defendant. This takes place in the U.S. Courts of Appeals. More specifically, the U.S. Court of Appeals for the Third Circuit. Starting with the facts. Ickes resides in Osterburg, where he owns a 38-acre tract of land that he refers to as both Ickes Airport and Ickes Recreational Park. Ickes claims to be an experienced aviator, and he has operated an airfield on the Osterburg property since at least 1987. Ickes seeks review of an emergency cease and desist order issued by the FAA. The FAA issued the emergency order to bring Ickes and his aircraft into compliance with federal regulations and to prevent the flight of aircraft during a weekend of flyby demonstrations that Ickes planned to conduct on his property in Osterburg, Pennsylvania. Ickes claims that the FAA abused its authority in issuing the emergency order because he flies only ultralight vehicles, which, unlike aircraft, are not subject to federal certification and registration requirements. He also contends that the circumstances surrounding his airshow did not give rise to an emergency to justify the issuance of a cease and desist order with immediate effect. The issue. Did the FAA err in subjecting Ickes and his aircraft to regulation? And did the FAA err in determining that his airshow posed an exigent danger, warranting an immediate response? Here's the holding. The court held that the FAA did not err in subjecting Ickes and his aircraft to regulation, or in determining that his airshow posed an exigent danger, warranting an immediate response. The court, therefore, affirmed the emergency order. Let's look at the reasoning behind all this. Let's first check whether an ultralight vehicle is indeed an aircraft by looking at 14 CFR Part 103. An ultralight vehicle is defined in relevant part as one that is used or intended to be used for manned operation in the air by a single occupant and, if powered, weighs less than 254 pounds empty weight, has a fuel capacity not exceeding 5 US gallons, and is not capable of more than 55 knots calibrated airspeed at full power in level flight. Interestingly, an ultralight is not an aircraft as that term is defined under the law. Ickes' particular contention in this case was that his two-seat Challenger airplane that he flew from his property for many years qualified as an ultralight vehicle. The FAA and the court disagreed, however. Based on its physical characteristics, Ickes Challenger 2 is not an ultralight in that the airplane had an empty weight of 300 pounds, a fuel capacity in excess of 5 gallons, and a potential cruise speed of approximately 56 to 69 knots. Now let's identify and list the regulatory requirements applicable to aircraft that are not applicable to ultralights. Unlike aircraft, which can be operated only if registered under 49 U.S. Code 44103, vehicles that meet the definition of an ultralight presently are not required to be registered or to bear markings of any type, are not required to meet airworthiness certification standards, and their operators are not required to meet any aeronautical knowledge, age, or experience requirements, or to have airman or medical certificates. Let's look at the remedy the FAA sought. The FAA required in the emergency order that Ickes immediately cease and desist from operating the Challenger 2 or any other aircraft until such time as he obtained airman, airworthiness, medical, and registration certificates, affixed appropriate identification markings to his aircraft, and submitted the aircraft to an authorized person for appropriate maintenance inspection and approval for service prior to operation. Ickes challenged the FAA's action in several ways. Let's talk about how the court resolved Ickes' arguments under the Commerce Clause. So Article 1, Section 8, Clause 3 of the U.S. Constitution says that Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. That's the Commerce Clause. Ickes argued that Congress lacked Commerce Clause authority to regulate his operation of the Challenger 2 because his flights were purely intra-state, within the state, recreational activity that did not affect interstate, between multiple states, air commerce or endanger air safety. Note the difference here between interstate and intrastate commerce. The Supreme Court identified three broad areas of activity subject to regulation under this Commerce Clause: the use of the channels of interstate commerce, protection of the instrumentalities of interstate commerce or persons or things in interstate commerce, even though the threat may come only from intrastate activities, and lastly, activities having a substantial relation to interstate commerce. According to the court, there was no dispute that Congress's power over interstate commerce included the power to regulate use of the nation's navigable airspace, which is a channel of interstate commerce. In addition, because airplanes constitute instrumentalities of interstate commerce, any threat to them, such as the one posed by Ickes' flights of his Challenger 2, was properly subjected to regulation, even if the threat came from a purely intrastate activity. Ickes' constitutional challenge, therefore, was without merit, according to the court. Lastly, let's discuss how the court characterized the FAA's authority to respond to emergencies and by what standard the agency's actions were reviewed as a matter of law. As to the FAA's authority to respond to an emergency, Congress has conferred broad power upon the FAA administrator to conduct investigations and to issue orders that the administrator considers necessary to carry out the FAA's mandate. Moreover, the administrator has the express power to act quickly and decisively in response to perceived air safety emergencies. In view of this broad discretion, the court's standard of review when assessing an FAA response to a perceived emergency was deferential. The courts ask only whether the finding of an emergency was a clear error of judgment, lacking any rational basis in fact. Here, the record revealed no clear error of judgment. The court reasoned that the FAA duly noted the inherent public danger posed by those who operate aircraft unlawfully in this country. Ickes, moreover, had a verified history of unlawful operation of the Challenger 2. The FAA had received reports in early 2001 that he continued making such flights, and Ickes' advertisement over the internet invited the public to gather on his property for a weekend of flyby demonstrations. It is undisputed that the demonstrations were to include the Challenger 2, an aircraft that Ickes failed to have certified as airworthy or inspected by an authorized mechanic.